So Murray, thanks for joining us today. We're going to record an interview for Law, Advocacy, Activism and Change. And we're particularly interested in work that people do that is either in discussions around legal change or intended to affect legal change. And I know that you have been involved in the parliamentary inquiry into freedom of speech, and I thought perhaps you could talk to us a little bit about what you did in that particular submission. And
sure. Would you like me to provide some background on the legal controversy?
that would be great.
Sure. So, I imagine as many students know, Section 18C of the Racial Discrimination Act has been controversial in Australia, and that's the law that makes it unlawful to offend, insult, humiliate or intimidate someone because of their race or ethnicity. And if someone feels that the section's been breached, they can initiate a process with the Australian Human Rights Commission that attempts to conciliate the parties. And if that fails, it can proceed to federal court, which can make various orders ranging from an apology through to compensation. And there have been a number of high-profile cases around Section 18C. One that students may be aware of is the Andrew Bolt case, which related to a series of articles which he'd published on Aboriginal identity. And as well as that, there was a case involving 3 students at the Queensland University of Technology. And the issues surrounding 18C are complex. There were concerns about the procedures followed by the Australian Human Rights Commission. In particular, in the QUT case, some of the students had been notified of the complaint initially. And it was felt that that breached sort of standard, what we call natural justice procedures that should be followed where there's an allegation. And there were also concerns about the substance of Section 18C. In particular, I think a lot of people have felt that these words offend and insult go rather too far in restricting free speech, and they apply to communications which shouldn't be unlawful in democratic discourse. So this kind of controversy had been brewing, and partly as a result of that, the Joint Committee on Human Rights was asked to conduct an inquiry. It was rather grandly termed freedom of speech in Australia, because it wasn't actually about freedom of speech generally, it was just about Section 18C. And they were asked to consider both the procedures followed by the Australian Human Rights Commission as well as the substance of Section 18C. And I should mention there's also Section 18D, which contains various exemptions that can apply. We're not going to discuss that in detail, but it's important to note in understanding how the Racial Discrimination Act works. And they were asked to make recommendations about whether there should be either procedural or substantive reform. And so there's an interesting set of issues there. And Adjunct Professor Holly Cullen asked both you and me if we'd be willing to draft a submission to the committee, which we did. And I think one of the great strengths of us working together is that we had different areas of expertise. And so we could contribute in various ways. So, as you know, the parts that you covered were the conformity of Sections 18C and 18D with international treaties. I looked at the position in comparative law and Australian constitutional law, and Holly covered the European Court of Human Rights. And I think our view that we developed was that we didn't address the procedural controversies surrounding Section 18C, and I think there was actually quite a wide consensus that some change was needed there. We're more interested in the substance of Section 18C. And part of the reason why this has been a complex issue is that the way in which the federal court has interpreted the law is different from its ordinary meaning. So a court can sometimes apply the law in a way that differs from how it's understood in ordinary English. And a lot of the controversy around 18C is that it's felt that these words offend and insult are just too broad. But if you actually look at how the federal courts interpreted those words, they said it should apply to communications or acts having profound and serious effects, not to be likened to mere slights. And our view, there are various views, but I'll talk a bit about sort of, I suppose, my part of the submission that we drafted, was that we were actually happy with the operation of the law in federal court. We didn't think it needed to be changed. The federal court had pitched the standard at about the right place. If there was to be a change, it should be to clarify what the law actually means in its operation. So that might have some effect of making the law better understood in the public mind. So that was one of the points the submission addressed, but the submission also did address, as you know, conformity with international law and some of the comparative law and law from the European Court of Human Rights. So you asked earlier about legal change. In a way, we were not arguing for change. We're arguing against change. But given that there was at that stage some momentum for reform, we wanted to inform those discussions. And as it turned out, the committee actually did invite us to give evidence, which we did in Perth, which was a really interesting experience. So that's the background to the submission.
That's really useful, I think, and I think it presents a really good understanding of the broader context, because part of what we're really discussing throughout the Law and Society major is that connection between law and society. And it seems from what you've said that perhaps some of the questions around this inquiry were more the society's perception of the law rather than the actual operation of the law. So I think that's an interesting example. What happened after this inquiry by the Parliamentary Committee? What did they conclude?
Well, the Parliamentary Committee produced a report which had a series of recommendations. There are some fairly clear recommendations about procedural reforms. As far as the substance of Section 18C and 18D are concerned, they couldn't agree. And so there were, I think from memory, 5 or 6 different proposals that were reflected in the recommendations that were supported by one or more members of the committee. And that's because the Joint Committee on Human Rights it's a cross-party committee. It contains various political perspectives. And this is a politicised issue in Australia. And so there is almost a sort of party line that's sometimes followed on Section 18C. And so a clear recommendation didn't emerge. Nonetheless, the Turnbull government did make a set of proposals for reforming Section 18C. Again, some of those are procedural in nature and less contentious. As far as the substance of Section 18C is concerned, what was recommended is that the words offend, insult, and humiliate be replaced with the word harass. My own sort of response to that is I wasn't sure what they were trying to achieve through that change. So we made a submission that there is a case for bringing the ordinary language of the section in line with the federal court's application of the law, and I wasn't sure if the government was trying to do that or whether they're trying to change the standard, and they didn't actually address that issue. And it may be because it's politically fraught, and for that reason they didn't want to be too specific about what they were doing. The other rather interesting change that was proposed was that at the moment, when the federal court applies this law, which refers to acts that are reasonably likely to offend, insult, humiliate, or intimidate on the basis of race or ethnicity, they apply a reasonable person test, but the reasonable person is a member of the relevant group, right? So it's not actually the person who's brought the complaint. They say, for example, how would the reasonable Aboriginal or Torres Strait Islander person, for example, respond to this communication? And what the government proposed is that the reasonable person test be changed, that it refers to a reasonable member of the Australian community as opposed to a reasonable member of the relevant group that has brought the complaint. And my view on that was that this seems to be capable of undermining what the law is meant to achieve. It's there to protect minority interests in large part. So if you're excluding minority perspectives from the operation of the law, that's problematic. I mean, the reasonable person test is always a difficult one, but the obvious question is, well, who is this reasonable member of the Australian community, and are they sensitive to minority concerns? And especially given that this section is meant to operate in a way that conciliates parties, I think it's rather important that it should be informed by minority perspectives and not attempt to exclude those perspectives. So, I mean, although I could see a case for some change to the language of Section 18C, I didn't think that those proposals were in line with our submission. As it turned out, they were blocked in the Senate, and so they didn't happen. And interestingly, this issue's now sort of receded from public discourse, possibly because other things have taken its place, like, for example, we had the plebiscite on same-sex marriage subsequently, and it might have crowded out discussion of Section 18C. So, sort of reflecting on it, I actually think, even though we weren't arguing so much for change, or we were sort of supporting minor change, I think where we might have succeeded is that our submission actually was cited in the report. Mm-hmm. And some of the members of the committee ended up supporting something like our proposals, and the fact that a fractured view emerged from the committee probably helped undermine some of the momentum for change, because people could see there was a plurality of views. The Senate didn't support the change, and so the changes didn't go ahead. So not to say that our contribution was decisive in that process, but I think at least we helped contribute to some kind of understanding of the complexity of the issues.
Thanks for that. And I think that it's an interesting example of how academics can provide some expertise or make an important contribution into those types of debate. Given, particularly as you say, at that time, it was really quite a politicised issue. Did you have any concerns about your participation in it? What types of things did you consider when you, because you also then subsequently wrote something which went online. So did you go through any kind of decision-making process around your involvement in something that was of this nature?
No, I didn't. I thought it was an exciting opportunity. I had a fairly clear view, which I was happy to articulate. I must admit that having published those conversation pieces, I could see there were a lot of comments. I didn't read through all of them, because the comment sections I find often best avoided in newspapers and other such online forums. So, I mean, I didn't, beyond making those contributions, then start engaging with sort of random people commenting. I didn't think it was a productive use of my time. There was a radio interview that followed that too, on 6PR radio, which, again, I just managed to sort of put across the views that we'd expressed in the submission and in the conversation piece.
Thanks for that.
And the interview was fairly fair, although there were some fairly Australia-specific type questions that I might have struggled with a bit, but at least I think I managed to convey the relevant law.
Thanks for that. So one of your sort of research areas is human rights and economic and social rights in particular. Do you think there's any opportunity there to do similar types of work, or to do sort of advocacy type work in terms of particular groups of right holders or particular issues?
Yeah, I mean, one of the things that this process alerted me to was that actually these opportunities exist. And if it hadn't been for Holly Cullen, I wouldn't have drafted the submission, and I wouldn't even have been probably been alert to the possibility. So I think it's great that she asked us both to be involved. And I think it's good just to bear that in mind when there's similar inquiries in future. I don't have a specific example in mind, but I think given the combined expertise of the law school, there are lots of ways that we can contribute. And it was quite rewarding to see our submission actually cited in the final report and to see our views reflected there. And I think too, reflecting back, you may remember that immediately prior to our oral evidence, there was another group of academics who took quite a different view to us. And in particular, they argued very strongly that this section was unconstitutional. And we were able to push back on that a bit in our evidence. And I think it was very useful for the committee to see or hear those different views. So if they'd just heard one view, they might have been more persuaded by it than they might otherwise have been. Yeah, I mean, I think these are great opportunities. It's great to see one's expertise actually being applied, and it's certainly something I'd like to do more of in the future.
That's great, thank you. And just something to maybe reflect on. I remember during the inquiry when we gave evidence, and then the Aboriginal Legal Service gave evidence after us, and the committee seemed to have a lot of questions about what I would call strategic litigation. So where, in order to raise an issue, for example, about a particular cartoon, I think was the example that was used, that an individual had to bring the case. And in some way we might reflect on that as perhaps a failing of a Western system of law, which prioritises the individual over the collective, and so to some extent to make it work, even if as a collective you feel harassed, let's say, by a particular image or story. The only way that you can really address it at the moment is, in a legal sense, is through an individual case. What's your reflection on that? Do you think that is a problem with how the law works? And do you think that, my sense was perhaps that the committee struggled to understand what it was people were trying to do when they assisted individuals to take the case?
That's a really interesting question, and there's an awful lot to say on that. I mean, as you'd know, in both international law and in domestic law, there's very often a standing requirement. So the person who brings the complaint has to have been personally affected in some way. And that can filter out issues from being brought to decision-making procedures because there's no one person who's willing or no one person's been sufficiently affected to bring the complaint. The law doesn't have to operate that way, though. So in some jurisdictions, we have seen a liberalisation of standing rules, allowing other groups or individuals to bring complaints or legal procedures acting in the public interest. So an example I'm familiar with is that under the South African Constitution, for example, anyone can bring a constitutional law challenge acting in the public interest. They don't have to be someone who's been personally affected. Now, the court can decide they're not acting in the public interest, so that can exclude the so-called vexatious litigant or someone who's might sort of waste the court's time. But what it has enabled, it's enabled NGOs, for example, to challenge government policy in various areas, such as government policy on HIV/AIDS under the Mbeki presidency. And they didn't have to search for the particular individual who'd been adversely affected. They could actually, just acting as an NGO, go to court, even if none of their members had been adversely affected by the policy. The court just had to be satisfied that they're acting in the public interest. So I don't think that the legal system has to focus as obsessively on standing as it sometimes does, because I think the concerns about vexatious litigation can be dealt with in other ways. I would just say, though, in conjunction with that, an interesting observation is that sometimes, especially in common law systems, individual facts seem to be important both in swaying the public mind and the judicial mind. So sometimes from a strategic point of view, the individual story relating to the person who brings the case can have strategic value. And in a sense, that's a different consideration. But I don't think that the legal system has to have strict standing requirements. I think it can operate more effectively without those in these kinds of areas.
That might be the next project that we work on.
Yes, yeah.
The South African example is really interesting. Do you know if, for example, the HIV case, were they successful?
Absolutely,
Yeah.
And that's a case I teach in my Evolution of Human Rights unit in the Law and Society major. And in that case, Thabo Mbeki, who was formerly president of South Africa, had some rather eccentric views on HIV/AIDS and was obstructing antiretroviral drugs that were known to assist people according to the available medical opinion. And an NGO called Treatment Action Campaign went to court and argued that the policy was unconstitutional and succeeded. The Constitutional Court unanimously ordered the government to change its policy, which they did. And so they didn't have to seek the individual litigant who'd been adversely affected. This specific case was about a drug called nevirapine, which is administered to pregnant women who are HIV positive to prevent transmission of HIV/AIDS to their children. And they didn't have to find a pregnant woman who'd been denied nevirapine in a public healthcare facility. They could just argue as the NGO. So you have these liberal standing rules under the South African Constitution. I'm not aware of these having created adverse consequences. Like sometimes a concern is raised that if you liberalise standing, you get a flood of litigants. That hasn't been the case. And these kind of cases wouldn't have been. There have been others too. This is just the one I'm most familiar with. Wouldn't otherwise have been possible. At least they would have had to be brought in a different form.
Thank you.